And this time, the gun goes off. And
Where did it go off?
right between his legs, went through his groin, through his scrotum. Penis got hit pretty bad, but didn't blow the penis off.
Hello, everyone, and welcome to another awesome episode of Cases Gone Wild, where I, Jon Marko, and Marko Law bring you the wildest, craziest, most insane cases from around the country that are real-life cases here on our podcast. Today, we have a great show in store for you. If you like us, please share, give us feedback. You can find us on all your streaming platforms, and we are video recording here. We're live in the studio, the podcast Marko Law Studio. So please look for us on YouTube, and you can actually watch and see. We dressed up nice for you today. It's going to be a great show today. Today, I have a great attorney, a very, very accomplished attorney, Tyler Joseph. Tyler, full disclosure, is an attorney here at Marko Law. You are the first Marko Law attorney that I've ever had on the show, and I'm so proud of you. And we're going to talk today. Tyler, you recently tried your very first case all on your own as first chair, and you obtained a verdict of $4.5 million that we're going to talk about today, and how you too can learn some tips on how you can try a case, because that's a damn good result. I'm very happy to have you on the show. We have some exciting cases. We're going to talk about a guy who had his nuts blown off by a gun that turned into a lawsuit that's going to trial. We're going to talk about bikes exploding and piercing people's eyeballs out. We got all kinds of crazy stuff. So let me tell you a little about Tyler. Tyler Joseph grew up in Lansing, Michigan. He's an outdoors guy. You're a very kind of chill dude. You were into the outdoors, fishing and hunting and things like that.
Try to be,
yeah. Went to Michigan State. And you studied in Lebanon. You're Lebanese, right?
I am. My grandfather was Lebanese.
Okay. And so Tyler Joseph, is that like Catholic Lebanese or how does that work?
Yeah, we're Christians. A lot of the early immigrants to the United States from Lebanon, the Christians took Old Testament names as their last name. So a lot of Josephs, most likely Lebanese.
Right. Okay. And you also attended Wayne State University Law School, where you got a full ride?
I did, yeah.
Man, you're a lucky dude, man. You don't have
know.
those loans. So, and Tyler, career, you started at what used to be called Hilborn & Hilborn, which was a boutique products liability firm. So for those of our people that don't know, this is products gone wild that hurt people. Like your toaster explodes and blows up in your face and hurts you. You can sue the toaster manufacturer. Very difficult area of the law. You studied and you learned from Craig Hilborn, who was a very accomplished, he's retired now, but very accomplished products lawyer. You came to work with us because Craig works with us too. You took a hiatus and you went to Mendel Law, and then you came back.
I did.
And you're back here. We're glad to have you. You're a great dude. I'm honored to have you on the show and to have you as an attorney.
Yeah, thanks, John. Thanks for having me on.
Let's talk about this case, man, because I know I've been busting your chops. I've been always saying, come on, Tyler, when are you going to go and get into a trial? And it wasn't from a lack of want. I mean, you wanted to go, but you can't. Sometimes cases settle. You did such a good job on them. They settled, or it just wasn't right. So tell us about this case, that it wasn't even your case for trying your first case. This was another attorney in the office who ended up leaving, and you volunteered basically and said, I want to go try this case in Ann Arbor. I want this to be my first case, and I'm going to go give it a shot. So tell us about this case.
Yeah, so I was chomping at the bit. I wanted to get in trial. It's not something you can force, though. I mean, you know that.
Right.
You got to wait for the right opportunity, and this was it. It was a good case. I liked it from the beginning. We'll get into more about the complexities of it. But generally speaking, it was simple. The accident was on camera, which is something, you don't have in the majority of your cases. The client, Alex, he was a oil tech at an oil change shop, And one day he was directing somebody into the bay. It wasn't an oil change. The guy was getting his tires rotated.
Okay, so is this like, like something like, when you go to Valvoline Instant Oil Change where like the customer has to drive their car in to the garage thing over the pit?
Exactly. So Alex is standing there directing the guy in.
So Alex is the mechanic, our client?
Right.
Okay.
Yep. He's directing the guy in, and all of a sudden the vehicle accelerates forward. It hits Alex, and it drives him through the garage door of the shop.
So wait a minute. So Alex is trying to tell the guy like, left, right, almost like a car wash, where the guy's guiding you in.
Exactly.
And the dude hits the gas who's driving the car instead of the brakes and smashes into Alex.
Right. We'll get to that later. You know what's coming up. But yeah, I mean, that's what it looked like. The guy accidentally hit the gas, accelerated forward, hits Alex, drives him through the garage door.
So the car actually hits Alex, pins him, and blows this garage door out.
Right.
Did you have pictures of the garage door and stuff?
Oh, yeah. We had all the pictures. We had all the damage.
You can now see these pictures on the YouTube channel of the garage door. And let's also look at this video that we're going to be able to show the viewers of the actual incident.
Part of the reason that it was complex was that Alex, he was in pain from day one. The issue is that through all his treatment, the doctors never could really tell him what was wrong.
Like, did he break any bones when this car smashed into him and blew him into this wall?
No broken bones.
Okay, he's lucky. He was lucky he didn't die, really.
He was very lucky. And he was having a lot of back pain doing simple things, and he was going to different doctors. They were telling him, listen, this isn't uncommon, but I can't point on your MRI and tell you, hey, this is where the pain's coming from, or this is what's wrong. And so it was really, really frustrating for Alex. He got a lot of treatment, but at the end of the day, the doctors said, this is chronic at this point. We can't pinpoint what's going on. You're clearly injured, but I can't show you on the MRI. I can't show you on the X-ray. And
that's always hard because like the gold standard for juries, and especially jurors who want proof, some jurors will say, I want to see it. And if you have a broken bone, you can show the X-ray of the broken bone. If you have an MRI image, you can sometimes say, look, here is the disc, the vertebrae disc in your back that's blown out. And here's the disc and here's the nerves, and you can see that the disc isn't where it's supposed to be. That is easier to show the jury and say, look, this is black and white.
Right.
I think a challenge here was, yeah, he was blown into the garage door. Yeah, he had pain. But we didn't have like a little image we could show the jury to point exactly this and this, right?
Right. And the other side of the coin is when the defense sees that, they see that as ammunition. Hey, look at this guy's not being honest. He's lying. Look at the MRIs. There's nothing there that's objective. That's, the word that we have in no fault that they always use. There's no objective finding. And they use that. I mean, they repeat that. And in this trial, they did. I mean, it was constant. Look at the MRIs. Look at the MRIs. But we were really thankful because Alex had some very, very good treating doctors, a pain management doctor who was able to come in and say, listen, I see patients like this all the time. I can't point on the MRI where the pain's coming from, but they're in pain. I know
there's nerves in there.
Right.
There's muscles, there's ligaments, there's soft tissue that doesn't show up, right?
Right, exactly.
So this is what's called in the legal jargon a soft tissue injury, right?
Right.
And as we know, they don't want to pay insurance companies because the driver who was driving this vehicle had an insurance policy through, who was it? Was it?
It was
State Farm?
State Farm, yeah.
Okay, State Farm, who said what? How much money did they offer before trial?
The last offer was $22,500.
$22,000.
Yeah.
And then after we had to take all the fees and then an attorney fee, Mr. Hamoud would have been left with what? A few grand if he's lucky?
Barely anything.
Barely anything.
Yep.
And so, all right, so we go to trial and we try this in Ann Arbor in front of Judge Connors, who's retiring, right?
Great judge.
And great judge, smart guy. He knows what he's doing. So take us through what happened and what you were expecting for your first trial. And how did it feel?
Yeah, obviously, I was really nervous. My opening was pretty stiff. I had Craig Hilborn there, Steve Natt was there helping me out, and I made it through my opening, but I was pretty nervous.
Did you feel stiff?
I did. I knew I was.
Yeah.
And you're nervous, and I had a PowerPoint, which may have been a bad idea. I felt like a professor up there lecturing. It was just a bad feel. I didn't like it, and through the course of the trial, it got exponentially better. I found my feet. I got more comfortable.
Yeah.
But opening was pretty stiff, and things went pretty smoothly until the defendant was called to testify.
Yeah. No, I was there with you, and let's talk about this. So when you are nervous, it makes you, me at least, and I think most people, act even more stiff because we're nervous. So we fall back on our protective mechanisms, which is we be more lawyerly and we use big words and stuff, which actually then makes it even more stiff, right? It's like a self-fulfilling prophecy.
Right.
So, and a lot of that just comes with time, being there, feeling more comfortable, doing it. There's really no secret sauce. The more you do this, the better it gets. As Mike Tyson would say, everybody has a plan till they get punched in the face, right?
Right.
And so you did a great job, and I'm sure you're going to continue to do better. But tell us about what the defendant said, because the whole time the defense said what? What was their explanation for this?
Before trial, I went back through, read all the depositions, everything. His explanation was, I don't really know what happened. That was what he said. And even the defense attorney got up in opening and said, he's going to tell you he doesn't really know what happened. And so I call him, he gets on the stand, and that's exactly what I expect him to say. And I'm all prepared to cross him, to deal with it.
And for our viewers, this case has been going on for how many years? When was the incident?
December 7th of 2020.
So like 4 years old.
Right.
So he had 4 years to figure out what happened. So
4 years, and he's on the stand, and I can't remember exactly what I said, but I said something to the effect of, it's been 4 years. Are you prepared to take responsibility today for what happened? And he said no. And I asked a follow up, and he said, well, as I'm pulling in, I hit my EcoBoost button. He was driving a Nissan Leaf, which is an electric car. He said, I hit my EcoBoost button, and the thing just accelerated forward. I didn't do anything. I just hit the EcoBoost button, and it accelerated forward. And I had to take a minute because I didn't expect
you looked in shock.
This came out of nowhere.
Everybody was in shock.
I'm not that familiar with EVs, so I'm like, what's an EcoBoost button? Like, how do I continue to examine them? I don't even know what this is. And so I take a little bit of break. I talk to you. I talk to Steve, and I was able to wade my way through it. What was really, I think, enlightening for the jury was that he claimed that the car magically accelerated when he hit this button, right? But after the fact, he told him, I never took it to a mechanic. I didn't really think to call Nissan. I just continued to drive it around.
Yeah, his story made no sense.
It made no sense.
And an EcoBoost button is like a button to save gas mileage on your car. And what really was shocking to me is they had 4 years, and this was obviously a fabrication. And the best thing that they could come up with was that he hit a gas mileage button, and it sent the car launching forward like a rocket ship. Suddenly, I mean, that doesn't happen, okay? And if God forbid that did happen, you did a great job of saying, well, wait a minute. Did you tell anyone at the scene that your car suddenly lit up like a rocket ship because of EcoBoost button? No. Did you call the dealership? No. Did you take it in? The guy's at a repair place.
Right.
If his car suddenly malfunctioned and blew up like a rocket, why wouldn't he tell them? Oh my God. Or the police, or anybody.
And what's worse is, and I really hammered this in closing because I was thinking a lot about it. He didn't do any of that, and he continued to drive that car around. The guy was from Ann Arbor, through campus.
Around kids.
And his argument, what he wants the jury to believe is, I just kept driving this around knowing that at any minute it could just fly forward and kill somebody.
Right.
It made no sense.
Because he could have killed our guy. My guy could have easily been killed when he got smashed into that wall.
Absolutely.
It was clearly, the jury clearly thought it was a lie.
Yes.
Complete lie.
They did.
And
and afterwards when we interviewed the jury, they were pretty clear. They didn't buy it for a second.
I mean, you don't, if something that bad happens where your car suddenly launches like a rocket ship, you're going to tell everyone. You're going to tell the police. You're going to tell everybody. It was clearly made up. I was kind of shocked at the gall of the defense, or who knows. I don't know if his lawyers, it's hard to imagine his lawyers didn't know that he was going to come up with this ridiculous crock of shit.
No idea.
But what, I think that those tactics where you make up stuff and you refuse to accept responsibility is good for our case. Because I remember you were really worried, and you're like, oh my God, what if they believe this? And Steve, the jury consultant was like, this could be fodder for a bad jury. And I kept saying, nobody's going to believe this shit.
Well, what really scared me was after this whole thing happened, Judge Connors allows the jurors to write notes, ask questions. Then there was one question that came out, can you elaborate more on what an EcoBoost is? And I'm like, this is over. They're going to be thinking about this the whole trial now. They're going to be back there deliberating, saying, well, maybe something did happen with his car. Maybe it's not his fault. And in the end, they didn't, but I was really worried for a while there.
And that's where you're a good lawyer. Look, we worry about everything. On the biggest verdicts I've had, 8-figure verdicts, okay? 8-figure verdicts, tens of millions of dollars. I was still worried till that verdict came in. And I was still thinking about things that I could have done better. Did I explain this right enough? Because you just never know. But I felt pretty good about this. I saw how it all went down. You handled it very well. And then another thing that we did immediately, and this was my contribution to the trial, so to speak, because I was sitting in the gallery,
right,
and I couldn't contain myself of this absurdness. So I ran up. We went up to the bench and we told the judge, please send the jury out after you had asked all these questions. And in Michigan, you can't just make this shit up in the middle of a jury trial, right?
Right.
So in Michigan, if you want to blame somebody else, you have to tell the other side. So like if your car malfunctions and suddenly turns into a rocket ship, you need to tell the other side at the beginning of the case and say, Nissan is at fault in this case.
Right.
And there's 100 reasons for that. So we're not surprised. So we could sue Nissan if we need be, whatever. And they never did that. They made this up in the middle of a trial. And so Judge Connors said he would give us a mistrial, which would be a reset. But he said basically like, be careful what you wish for. Do you really want this?
I think he said, well, you aren't getting another trial date for 8 or 9 months.
Yeah.
So,
And we said no. We said, but you need to instruct the jury. And he did. The jury came back out and he said, he was very cool. He's like, remember all that stuff about an EcoBoost button and rocket ship stuff and all this? He goes, just forget about it. It didn't happen. It didn't happen. Which you have to do. You handled that correctly. The story was so ridiculous. You made the witness look like a liar for making it up. And then on top of that, we were able to have the judge give the force of law to say that. And with those two things, I think it secured it very well. And I think ultimately they did you a favor by making this crazy stuff up.
I think they did. And people already kind of know this, generally speaking, but especially this trial, one of the big things that I learned is the jury has to trust you. They have to. If they don't, it's over. It doesn't... it may not even matter what the facts of the case are. If they think you're up there trying to pull one over on them, it is over. And I think that's the vibe they got from the defense in this case. And I was so anal about making sure that I didn't do anything that would even appear as though I'm trying to stretch the truth. And I think at the end of the day, that's what saved me. They trusted me. They clearly knew that the defense was... I don't know what happened, whether it was made up,
there was
whether
some
it was
bullshit somewhere.
Something happened,
it stunk to high
major
heaven.
Miscommunication. But regardless of what happened, the jury thought they were getting. And in closing, I told them, I said they could have gotten up during opening and said, "Listen, this is unfortunate, but there was something wrong with the car," and they didn't do that.
Or they could have done that 4 years ago.
Well, they
when
should
they
have,
got served with a lawsuit.
but I think it was even more so for the jury to know that, well, yeah, why didn't they say that during opening? Why was it when the defendant's on the stand, we hear about it for the first time? It was an ambush, and that's
Yeah.
what I said in closing. This was clearly an ambush. They could have told you in opening, and, the lawyers would have had a conversation with the judge, and we could have sorted it out then. But instead, we're halfway through the trial, defendant gets up and just throws this out there.
Yeah.
And I think
It did not go over well, I don't
it didn't, no.
Now, you talked about damages. Now, before you did closing, I remember something happened with an exhibit. And why don't you tell them about this? Because we've all been there, okay? And one of the things that's hard about a trial is there's a million things going on at once. Like, it's not just like you're focused, and especially, like on TV, you don't have like 100 people there, right? So
Right.
You're trying to keep everything together. You're trying to do the law, do this. So tell what happened with the exhibits, which I think was very dastardly.
Yeah, I mean, this whole situation made my stomach drop. There was another point during the whole process where I thought, man, I really screwed up, and it's my fault. And it was the second day of trial, I think, and we all had some exhibits that we had stipulated to. I had some medical records. I think they had their doctor's CV. I can't remember exactly.
And so our listeners know, most of the times now in trials, the parties get together and say, here are the exhibits. We just agree that these are the exhibits.
Right, so you don't have to go through the whole process of laying foundation, calling a witness to tell the jury.
It's a big waste of time.
Big waste of time. So we had talked, and I said, yeah, I don't have a problem with the CV. I can't remember what else it was. And they
so
said,
you and the defense attorney.
right. And so we go on the record. Judge Connors comes out, and Connors says, I understand the party's got some exhibits that they're going to stipulate to. I go through mine, 1, 2, 3, 4, and this is my fault. I'm not paying attention. And the defense attorney rattles off a couple, and at the last exhibit, they say video surveillance. And I had known about this surveillance. It had been disclosed. I didn't think it was going to come in because I can't remember at this point. I don't think they called the private investigator to lay the foundation for it, but I didn't hear it. And what happened was during closing, they start to play some of it.
So they basically pulled a fast one.
I think so.
You didn't agree to this exhibit, right?
They knew I would never agree to that. Whether they may have said it and I was so stressed out that I didn't hear them say it, I don't know.
But they rattled off a bunch of, Judge, we're entering exhibit 1, 2, 3, 4. Here's the names, blah, 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 blah.
And the other thing, too, was before the trial even started, we tried to get that surveillance struck. And judge said no. So they had to have known there's no way I would ever stipulate to this. So I felt it was a little underhanded, but at the end of the day, it was my fault, and I will never do that again. That's one of those things where, from now on, exhibits, they're stipulated to them. I want them in front of me, sitting in front of me. Go through them. It's never just let's rattle them off on the record. So
yeah, you got to be aware of sneaky stuff at all times, and it's unfortunate because that's not how we practice, by sneaking stuff in like that, in that way, if that's what happened. But it is, but that's when you do too much sneaky stuff and you get caught too, like, it blows your credibility. It blows your credibility from the judge. It blows your credibility from opposing counsel. Like, if we ever have a case with these defense attorneys again, right? You're not going to trust a damn thing that they say or do.
Nope.
I mean, they have no credibility with us.
And I was lucky because I think at this point in the trial, we were deep enough in that the jury already trusted me. And when they tried to get that in, I made another mistake. I blew up a little bit. And, Judge Connors is a great judge, but you could tell he was a little upset with me, jumping out during closing arguments. Hindsight's 20/20.
Yeah,
right?
yeah.
If I could do it again, I wouldn't have. But we had to go back on the record, the video record, and the jury's obviously not in the courtroom, but we're going through it, and they did say, because at the time I was adamant this was never stipulated to, this wasn't put on the record.
Because in your mind, you didn't agree to it.
No, nobody that I was there with on our side had heard it either. They're like, we didn't hear that. You would have never stipulated to that. But sure enough, on the record, they slipped it in, and so I had to apologize to the judge, and I had to apologize to the jury. And, I think in any other situation, a jury might have held that against me for pulling what seemed like a fast one.
Yeah.
But
you had built so much trust and credibility with the jury that they saw
I think so.
the truth, I think.
And after the trial, I asked him, I said, because I was talking to Steve, he's like, that was a mistake. You should have handled that differently. I think you lost some face with the jury. And so I wanted to know. I asked him, when that happened, what'd you think? And they said, we knew what was going on. It didn't bother.
You had built up so much credibility with the jury by that point. And what you said about credibility and being honest and having the jury trust you is so important. I will even underplay things sometimes, because if you can even lose trust by overplaying your hand and then having it not be as bad as you say. So
True.
I tried a civil rights case once where I made the officer sound like a very bad person, which when we showed the video, I think I oversold. And I felt like I should have undersold even, or if you make promises that you can't keep, whether you're on the plaintiff side or the defense, it can come back to bite you. So you got to be careful with that.
Yep.
But obviously you took a case, $22,000 offer, final offer. And what troubled me on this case is we had this video, we had the garage door. It was clear to me, this was a horrible type of incident, and that was just like a pittance. They forced it. And before trial, we said they had $1,250,000 of insurance. That was a lot of insurance coverage.
Right.
And we said, just pay the $250,000. Keep the $1 million in insurance, just pay the $250,000. They laughed at us. They said no. And then, so what was really awesome is you hear stories in the law about, they're like famous legendary stories about the jury asking for a calculator. So what happened in this case?
That happened. So the jury went out. They were out for a while. I think we started on a Monday. Wednesday morning, we closed. The jury goes out. They're out all day on Wednesday. They come back on Thursday. And I think it was Thursday, got a phone call from Judge Connor's chambers. We need everybody in here. Jurors have a question. We all go on the record. Connor's very serious. He says, well, they just asked for a calculator. Any objections? And before I could even stand up, he pointed at me and said, I know you don't have an objection. I want to hear from them. And the defense couldn't really object to it. What would be the basis? So they said no, and they got their calculator, and now I know what they were doing. And in closing, I had asked them to give future damages, and under the law, those future damages get reduced to what we call present value. I'm not an accountant, but there's a formula. You reduce the future damages because you're getting the cash in hand, so to speak, today. And they were compensating for that at 5% per year. So they were going through the future damages, running the numbers, and that's why they had asked for it.
So a calculator is always a good sign for the plaintiff, because that means that the jury is adding up how much of a verdict to give to the plaintiff. And what really boggled my mind is when the jury asked for a calculator, I was like, this is a great sign. And we went to the defense attorney at that point and said, look, you guys are now in trouble. There's going to be a verdict. Please just take accountability. We're going to give you one last chance for the insurance company to pay.
Right.
And they just blew us off again. And we said, pay the insurance proceeds only. Just pay us the insurance proceeds that are there. The $250,000 was off the table, but it was pay us what's left in the policy, the $1.25. And they didn't do anything. They didn't even come off. It was still, even when the jury asked for calculator, $22,000 was still the offer, which to me is just insanity. I mean, somebody's not doing their job. I don't know who it was. The defense attorney, the defense adjusters, insurance adjusters, all the above, who knows?
There was something about this case where somebody said, there's no way a jury's going to give them that much money on this. There's just no way.
Well, they were wrong. You did a great job. $4.5 million. And another thing that you did that took courage is, and, it's sorry to say, but we've seen disparity of treatment among plaintiffs. Okay. If you are a wealthy, white, professional from Oakland County, an insurance adjuster may treat you differently than if your name is Hamoud and you're living in less fortunate circumstances, maybe in poverty or here. And it's not right. And I think that did they kind of play that here with the fact that you had an Arab client, you had a lot of the witnesses were Arabic, right? The doctors, He felt comfortable treating with Arabic doctors from Dearborn, Michigan.
Right.
His family was obviously Arabic. So how did you deal with that issue? Because it was an all-white jury, wasn't it?
It was. And it's just one of those things, talking about it. We got it on video. They're grabbing at straws, trying to come up with an excuse why this isn't their fault. They're only offering 20 grand, 22 grand. Like, what gives? Why are they doing this? And, we'll never know, right? No one's ever going to tell us what the adjuster at State Farm was thinking. But this was a Arab American, Muslim young guy from Dearborn, and all the witnesses were Arab Muslims. You don't know. But, both you and I, we've done this long enough. You do see claims handled differently with different people, right?
Yeah.
And you always wonder what's going on, why. And they had the video that we had been out since the time this happened. They knew it was on video. They knew they didn't have a good argument as to why this wasn't their fault. So
did you face this? It's always tough to talk about discrimination, especially it can be a polarizing issue, especially when, there wasn't like some email saying like, don't pay this guy, he's an Arab American Muslim.
Right.
So did you address this at all with the jury?
I did. And I think what I kept putting in front of the jury was, I told him, I said, listen, what the defense wants you to believe in this case is that this is one big conspiracy theory between Alex, his friends, his family, and all of his doctors. They've all come in here and told you he's hurt. They've all come in here and told you about how this has impacted his life, the things he has to deal with now. And they want you to believe that they're all lying, that they're all in cahoots, and there's really nothing wrong with Alex. And I think I hit that point so many times, I don't know if it crossed their mind, but it may have. They saw it. They saw the witnesses. They heard them all, and I think they may have understood what was going on.
Yeah. I had a case in Wayne County where I had a poor African American. It was a medical malpractice case, and they never came out and said we gave this guy a less standard of care, but I think there was the implicit. It was there, and I said to one of the doctors, would you give this same level of care to your brother-in-law, or your brother? And, he's like, there's no good answer for that.
Yeah, so. It's wild because, again, it was all on camera. It's not even like they could come in and get away with making
up. They tried. It's crazy. I think they would have had a different result had that guy come in and said, I am so sorry. I made a huge mistake. I hit the gas. I probably hit the gas instead of the brake. There's no other explanation. I'm so sorry, but you got to be reasonable or something.
I don't want to give defense attorneys pointers, but I wholeheartedly agree. If they'd have come in and said, listen, this is unfortunate. It was an accident. We want to take responsibility. It's just a matter of, under the law, we have to find out what those damages are.
Yeah.
If they had done that, I think it would have been a different story.
Yeah.
But they didn't. They did not. They refused to take responsibility right up to the last second.
Well, good job. Well, all right, let's talk about some other cases gone wild. So I know you had, you're going to trial on a crazy case with some of the most horrific injuries I've ever seen for a gentleman up in Lapeer County who, tell a little bit about the case, because this is insane.
Yeah, so Mr. Doobie, He's born and raised in Lapeer County. This happened. This was a while ago too. This has been a long time coming. This was a 2019 accident. He's working for General Motors at the time. He's got a wife and 2 kids, and one of his buddies that he knows calls him up and says, "Hey, I'd really like to get out and do some hunting this year, some deer hunting. Do you know anywhere I could go? Any farms people are looking for, people to come on the property and take some deer?" He says, "Yeah, I used to work on this farm. I helped build it. I know these people really well. Let me make a phone call. We'll arrange it." So Michael gives another guy a call. He's the caretaker of the farm. And he says, "Hey, I got a friend. He wants to come up hunting. Is it a problem?" "Nope, never a problem. Come up, take as many deer as you want." These farms, they have an interest in keeping deer, other nuisance species off because they mess with crops. They eat the crops. And so, Michael said, it's usually never a problem. He just has to ask for permission because this guy, his name's John, he's the caretaker, the manager of the farm. And so one night, it's a Friday night, they go up to the farm, Michael and his buddy. They get there, and there's another guy on the farm. He's the caretaker's son. And this guy has a reputation for being pretty reckless. There's a whole bunch of stories. He's ruined farm equipment, rolled 4-wheelers, DUIs.
Isn't he like a felon too?
He was a felon, just
convicted felon.
One of these guys that just cannot stay out of trouble, right? And they get there, and Michael's like, "Oh man, I was really hoping Andy wouldn't be here," but he's the caretaker's son, And Michael,
yeah. What are you gonna do?
Yeah, what are you gonna do? So, he sees that this guy, his name's Andy too, Andy Brill. He's got a beer in his hand, but he's always got a beer in his hand, right? So he's like, he didn't seem that drunk to me, seem normal to me. And he's like, "Hey, I want to come out with you guys. I want to scout for deer," because that's what they're there to do. The deer season hasn't started yet. They're going to go out and scout. Michael's going to show Andy, his buddy, the good spots, the game trails, where to set up, all of those things. So they all go out and they all take guns with them. And the reason that they take these guns with them is because whenever they go out on the farm, they typically take guns. If they see raccoons, woodchucks, nuisance species, animals that they want to get rid of, they'll take them, right? And so they all go out. I think Michael has a 22 rifle, so a small caliber rifle, and the 2 Andys, his friend and the caretaker's son, they both have shotguns. They go out, they don't see anything. They show Andy, the friend, the lay of the land, tell him where to hunt. It's getting dark, so they go back to the truck. They had to drive.
Now, are the guys with shotguns boozing it?
Not at the time. No,
Okay.
At the time they're out there, nobody's drinking.
Okay.
And so they get back to the truck, and they're unloading their guns. Andy Brill, the caretaker's son, he doesn't have a headlamp on. And so he's trying to unload his gun.
Because is it dark out?
It's getting dark, yeah. He's trying to unload his gun.
And just so our viewers, because I know and the good ladies and gentlemen of Lapeer probably know a little better than a lot of people, but a shotgun has these shotgun shells in it, right? That are full of these little BBs. That's called like a...
Right, yeah. Yeah, you can buy slugs, which is like a big, almost like bullet inside the shotgun shell. But at this time, these guys had shells, which is what you call bird shot, the little BBs. Yeah,
and the shotgun can hold a bunch of different shells, right? Like 8 or 9 or something.
Right. So
and you load them in the bottom, right?
You load them in the magazine, and then when you're ready to rack them in the chamber, depending on what type of shotgun it is, if it's a pump, I'm sure everybody's seen a pump shotgun.
Yeah.
You rack it, and it throws one into the chamber.
Yeah.
Andy Brill, he had a semi-automatic gun, and so the semi-automatic, it's exactly what it sounds like. When you pull the trigger and shoot off a round, it automatically loads one into the chamber. You don't have to manually do anything. You don't have to rack it. It just automatically
keeps loading them in.
Keeps loading them in, like a handgun.
Yeah,
Same principle. And so Andy Brill can't see. Nobody knows why he does this, but he asked Michael, our client, "Hey, you got your headlamp on. Can you check and make sure my gun's unloaded?" Again, I don't know why he does this. He could have just put his finger in there to make sure there wasn't anything in the chamber or magazine, but he wanted Michael to look. Michael looks and says, "Your chamber's empty, but it looks like you got one more to rack in, so be careful." Michael goes back to unloading his gun, and Andy Brill, the caretaker's son, starts screwing around. He starts poking him.
Is he drunk?
Well, at the time, Michael doesn't know, but he is. We'll find out how drunk he is later. but he's screwing around. He's poking Michael between the legs, putting the barrel up between his butt cheeks. And
which, you're supposed to treat. I don't know a lot about guns, but my understanding is safety is you're supposed to treat any gun as if it's loaded at all times.
Exactly.
And like I went shooting out with Nick Rowley out in Montana, and we had a Navy SEAL guy, and he's like, pretend like there's a laser beam shooting out of your gun at all times, and you'll cut someone if it goes over them,
Yeah, you never point the barrel of a gun at anything you don't intend on shooting. And here's a really good example why. So he's screwing around. Michael says, hey, knock it off. And he does it again. And this time, the gun goes off. And
where did it go off?
Right between his legs, went through his groin, through his scrotum. Penis got hit pretty bad, but didn't blow the penis off. But
not completely.
But
it was like hanging there, kind of
right,
half off. And we won't. Look, this show, we have like viewer discretion, but we're not even going to show these photos on this show. It's too gruesome. But one and a half of his testicles were blown off, right?
More, I think. I think he's only got 30% of the one left.
30% of one testicle.
Right.
Can't pee out of his penis.
Oh, it shredded his urethra, all the muscles, what do they call those? The pelvic floor muscles. Completely shredded them.
Yeah,
this
was
gruesome
injuries. Some of the most horrific injuries. I think I'd rather like lose my legs or something.
For the trial, I sent out the pictures to be blown up, and Dave, he calls me, and I warned him beforehand. I said I need some blow-ups, but X-rated. These are pretty graphic. And he called me. He said, "Man, I've been doing this a long time, and nobody's ever got me. And when you sent me those photos yesterday, you got me. Those are some of the worst injuries.
Photos I can ever imagine.
Oh, it's terrible.
And our poor client, he's a young guy. He's in his 20s. He's underwent over like 12 surgeries, I believe. They tried to reconstruct. I went and took the urologist trial deposition. And the urologist said it was like one of the worst things he's ever seen. And this guy's like 65 years old. He's like one of the top urologists. He's been doing this for a long time. They were pulling BBs out of his genital area even like a year later. They were still finding BBs in there because they weren't able to get them all out.
I think he's still got some in there. Just that, because they aren't going to go in and create more trauma to get something that's benign at this point.
Yeah,
so
it's just stuck in there.
His body could be working out BBs for the rest of his life.
He had to wear a catheter with a urine bag on his leg for years, I believe. That thing kept getting clogged up. And then the guy has to pee sitting down now because he can't pee out of his pee hole. He has to pee out of almost like a vagina.
Right.
And so he has to pee sitting down. And you know what was the most weirdest thing? So I deposed the urologist because I'm working with you on this case. And he talks about how he has to pee sitting down and it's never going to be able to be fixed. And the defense attorney's cross-exam, which I thought this is an example of what not to do is, well, doctor, isn't it true that in different cultures, sometimes men pee sitting down? Like in France, they pee in bidets and they sit down. And I'm like thinking, what in the fuck are you talking about? And the doctor's like, sir, I don't know what you're talking about, but most guys I know pee standing up.
Yeah, I don't know if that argument's going to resonate with a Lapeer County jury, but...
Yeah, I don't know either. I doubt it. And these are the most gruesome injuries I've ever seen. And there's a lot more that we won't get into the show with how this has affected our client's life and his marriage and all this stuff. It's just so sad, but this is like extreme. I mean, all the money in the world. So, tell us about so is the farm responsible?
Well, that's a good question. So, and I don't know if I mentioned this before, Andy Brill, the caretaker's son, he got a gun from his father that night. His dad, the
gun that he shot our client with.
Exactly. And there's a question of whether or not that the father, the caretaker, negligently entrusted the shotgun to his son at the time.
So is this kind of like the Crumbly stuff? Like you can't give a gun, you can't entrust. It's called negligent entrustment. Like if I know that you're like a psycho stabber, Jack the Ripper, and you're like mentally unstable and you're going around stabbing people, and then I give you a knife and say, have fun,
Right.
I could be negligent, right?
Right. And it's all about, what that person, the entrustor, is on notice of. I mean, there's a million examples, but maybe there's an emergency and somebody runs up to you and says, hey, I need to get to the hospital. Can I have your car keys? And you give them your car keys. And then you later learn they were drunk, but you had no idea. There may not be liability there. It's all about
There may
notice.
be, right? If they smelled like booze or something,
Right.
whatever.
If they were stumbling up to you, they couldn't get their words out, that's notice. But in this case, after the fact, when Andy Brill was arrested, he openly admitted to the police that he had had over 8 beers, multiple shots in the hour or so before they went out hunting. Yes, he's had a lot of run-ins with the law because of alcohol. And, the argument is, why would you give this guy a gun when he's obviously drunk, when you know his reputation, you know what he's like, he's reckless? That's the argument. And obviously they're going to say, well, we had no idea he'd do something like this.
Yeah, that's a crazy case. That's an absolute crazy case. And, hopefully we can get some justice for the client on that case, which is going to trial. Let's talk about some other crazy cases. So you went to work at a different law firm for a while before you came back, right?
I did, yeah.
So, what do you think's the difference between, every law firm has kind of a different culture and a different way to approach what we do, even law firms doing the same type of work. Was there a difference in your previous employer and Marko Law?
Yeah, so I've worked at a few different law firms as, clerks and, when I was starting out. And, at Marko, the thing is we're always going to be able to try cases. And, there's never going to be any hesitancy about it. Well, I take that back. I mean, if there's an issue with the case, obviously you always got to be straightforward with your client, and not every case should be tried.
Right.
We both know that. But at some law firms, there's this baseline where we don't want to try the case unless we absolutely have to, like zero offer, And even then, sometimes they might call another firm and say, hey, can you come try this? There might be some excuse. So
why do you think that is, that they did that?
I don't know. I think just different firms have different models that they go by. Each firm has their own way of making money, and sometimes it might not be conducive with trying a lot of cases,
Yeah.
And I guess to each their own, but I've always wanted to try cases, since I first started working with Craig. Craig Hilborn tried a lot of cases, working for you, obviously trying a lot of cases. I wanted to be a trial lawyer. And so doing a bunch of discovery on a bunch of cases and then ultimately settling them, sometimes it's good for the client depending on the case, but, doing that day after day after day, it gets old, and I've always wanted to get in the pit, try cases. And now that I have, it feels great. And, hopefully a lot more to come.
You're doing a good job.
Yeah.
You're doing a great job. And that's a hell of a first verdict, because my first verdict was not a 7-figure verdict. Okay. So that was and that has to be a record for Washtenaw County on a soft tissue, as they like to call it.
Right.
Although that doesn't really do justice to what the client had to go when they used soft tissue, but that's a great verdict. Let's talk about, so you had a case that you brought over from your old firm that you almost tried.
Right.
And tell us about this case. What was it, up in Flint?
Yeah, this was in Genesee County. This was a dram shop case, which this. Dram shops are interesting cases because you always have this thing called the AIP, allegedly intoxicated person. And that's your link to the dram shop. You're a history major. You probably know why they're called dram shops.
Yeah.
But dram shop is a bar, place that serves alcohol. And so...
the idea is they have to serve responsibly. They can't serve drunk people more booze, because people can hurt and die. Because, they go drive a car, they go, do crazy shit.
And it's this visibly intoxicated standard. If somebody's stumbling up to the bar, they can barely talk. It might not even be that severe. If it appears that they're visibly intoxicated as a dram shop, as a bar, under law, you're required to refuse them service, right? Mm-hmm. So in this case, my client, really great guy, hard worker, carpenter. He's at a bar in Flint. And I'm sorry, it wasn't Flint. It was just outside of Flint, I think towards Grand Blanc. And he's on the patio. He's not even drinking that night. He's meeting a buddy of his who's a DJ at this bar, and they're exchanging some music. And they're on the patio. This massive guy, probably 6'5", 250, comes stomping out onto the patio.
Do they know the guy?
No. Nobody's ever met anybody
So
before.
just some random bar patron guy.
Some random bar patron guy, and this guy stomps up to a table on the other side of the patio, and he starts screaming at these two people. It's a younger guy and a younger woman, and my client and his friend see this, and they're kind of watching, and at one point, the big guy reaches back like he's going to hit one of them.
Why? For what reason?
They don't know. They're just out on the patio minding their own business. They just see this happening. So my client's friend stands up and says something to the effect of, "Hey man, leave those two alone. We don't want any trouble here. Nobody wants any trouble." The guy 180 turns around, comes for them now. And the big guy gets in a tussle with my client's friend. He's able to get away and crawls into the bar to get help. And then the big guy goes after my client. And they're grappling, ends up tearing his rotator cuff. Really, really bad tear, needs multiple surgeries. And then the big guy, AIP, leaves, jumps into a truck, speeds off.
Runs away.
So we're able to find this guy, and there's a lot of complexities with the case. They had cameras. They didn't have any video, though.
That shit always happens with bars. They
Right.
always lose the video.
Right. So
Every time.
So there should have been video, and it would have been great if we had video of this guy in the bar so we could see,
How much did he drink? Was he stumbling? Was he wasted? Did
Right.
he, all that stuff. Yeah.
Right. So we get into the discovery process, and I'm taking this guy's deposition. I took his deposition the first time, and he pled the fifth to every single question. That was the first time I'd ever come across this. And I had asked the court to preserve the assertions for trial and for an adverse presumption. And I had a really good judge up in Flint, Judge Lachana, and he said, let's just wait until the criminal matter's resolved, and then you can redepose him. So that's what happened. So I redepose him, and this time he's answering my questions. And I ask him, did you order any alcohol inside the bar? And he says, yes. What'd you get? He said, well, I ordered my favorite drink, Sex on the Beach.
Come on.
And mind you, this guy's 6'5", 250. He'd been in prison before. He had a criminal record.
Was he messing with you, or did he really like Sex on the Beach?
I think he was messing with me, but we'll never know. So he claims he ordered a Sex on the Beach. And then I ask him, well, how did you just have the Sex on the Beach? Did you order other drinks? Did you do any shots? He's like, I didn't even drink half of the Sex on the Beach because it was the worst sex on the beach I'd ever had in my life. And at this time, it's getting a little comical. But that was his story. Even the bar said, yeah, we remember him. I think we served him some Jack and Coke. So I'm pretty sure he was just screwing with us.
And there was no receipts.
No receipts.
Yeah, that's the problem too. The receipts go missing.
Right.
Suing bars is hard. I mean, for people that it's very hard to do a bar suit. You have the evidence goes missing or it gets lost. They don't have a lot of insurance generally. The insurance companies are cheap and horrible. They write like very cheap policies. They don't want to pay out on claims. And then even if you can prove your case, the jury has to break up who's responsible. So like if we would have tried this case, the jury would say that the drunk big guy is like X amount responsible out of 100%, right? So let's say they might say 80%, and then the bar is 20%. That's if we win, right? And then any verdict then gets reduced by that amount. So if it was $100,000 verdict,
20.
Yeah, the bar would only have to pay 20%.
And I think there's just this general feeling among people that, there are drunk people in bars all the time. Like how much responsibility is a bartender or bar owner really supposed to take? And the law is pretty clear about it. You know, it's that visibly intoxicated standard, but jurors, I feel like, are going to give a little bit more. And the hard thing too is they have this other person that they're free to just put all the blame on. So if you were just trying the case against the bar, it'd be a lot easier.
Yeah, but you can't do that. You
can't
have to sue the bad guy, the assaulter,
Right.
too, which makes it harder but they set it up like that.
So in this case, it got really close to trial. At the end of the day, we really felt like the juror's just going to blame this guy. The bartenders, they were young girls. They presented well.
Yeah.
The only guy in the entire litigation that is going to come across as an asshole is going to be the AIP, who didn't have any insurance, the drunk guy.
Yeah.
And he had a history of being violent. He had a history of steroid use. There was kind of no one really testified to it outright, but there were some whispers that this guy just had roid rage.
Yeah.
And there's a whole backstory.
So, I mean, and that's the other problem. Like, the worse, it's like a delicate balance as a plaintiff's lawyer, because the worse that the person, the drunk driver or the drunk assaulter or the drunk person, the worse of a person that they are, the more the jury's going to get pissed at them and maybe not the bar.
Right.
Right?
Yeah.
Unless the bar knew about it. So, like, normally it's a good thing to get the jury pissed about how bad the other side is. But in this case, might be disadvantage, right?
Exactly.
So, but yeah, that was an interesting case, I thought, though, just because these bar cases are always so wild.
They
wild.
are.
All right, so let's talk a little bit about products cases and products that are defective, because not a lot of people in Michigan do products cases at all. For our listeners, products cases, like I said earlier, it's some manufactured product that breaks and hurts someone. So if we look at your big verdict that we recently got, if that car had actually malfunctioned, the Nissan had just started driving itself and turn into a rocket ship, then you could have sued Nissan for a car malfunctioning. And this is in the news. I don't know if you've seen, like, Tesla got sued for, like, the self-driving malfunctioning and killing someone out in California. We see this in a lot of different types of cases, and it can be very simple things. I mean, I've done a case where a beer bottle exploded, like a Bud Light exploded, launching a bottle cap right into somebody's eyeball. And it was just that, like, they put too much carbonation in it or something. So these cases can kind of run the gamut. But you've done a lot of these, and I know part of that is Craig, who is like that guru of products in Michigan. They're hard cases. But let's talk about some of the cases that we've done. And one that I really kind of hold near and dear to my heart, although, warning, is this has a sad ending because we were not able to ultimately prevail, but was a case out of Slovakia, which is, by the way, Marko is Slovakian. So
I knew that. Yeah.
I really wanted to help one of my brethren. This guy might have been like, my like great cousin or something. Who knows? But tell the listeners a little bit about this crazy case out of Slovakia.
Yeah, so we had this the Slovakian citizen reach out to us. I think he said that he had found us online.
Yeah, Marko, baby. He saw the Markovic or something.
Must have been. And he didn't speak English very well, so we had a friend of his that was emailing, corresponding with me. We had some Zoom phone calls, and
he was over in the country of Slovakia, right?
Right.
Which is north of Hungary, Budapest, Hungary, in Eastern Europe. I mean, this was a long distance case. I was getting really excited to go to Slovakia on this case.
So he contacts us. He is an avid bicycler. And
am I, so I related to this dude. See, we are from the same family
same person, basically. And so he's riding his bike one day. I think it was some mountain biking. He wasn't on something that was causing some strain on the what is it?
The shocks.
The shocks, right.
And these mountain bikes have these shocks, so they're like, there's like a spring in them, right? So they can, like, shock absorber almost.
Yeah, they're pressurized heavily. And so he's riding, and all of a sudden he hears a loud pop, and he feels pain in his face. So he pulls over and he can't see out of his left eye. And he's trying to figure out what happened. At first he thought he was shot or something. And this bystander comes up, and obviously they're speaking Slovakian, but he says, this just came off your bike, and it was a cap or a portion of one of those shocks. As he was going over a bump, the shock just exploded and threw shrapnel into his face.
So the bike basically turned into a gun pointed at his eyeball that shot him in the eyeball.
It was a bomb, and he lost all vision in the eye. He lost the eye completely.
He almost could have died, right? Like, didn't the spring like penetrate, or the cap penetrate, and could have killed him?
Completely demolished his eye, lost sight completely. And he, very smart guy, did his own research, looked into everything, found out that the shock was designed, maybe manufactured by a company based out of Metro Detroit. So that's how he got in touch with us. We signed up the case, we filed it, and then, as you know, what happened next is a little disappointing, but it's an interesting area of law.
Yeah. So there was a bike designer and a bike manufacturer. One, like the parent company, the owner company was based out of Metro Detroit, right? And then there was an Italian subsidiary company based out of Italy.
Right.
And then the bike malfunctioned in Slovakia. So this is like a law school exam question.
All over the map. So the parent company based out of Detroit, they immediately file a motion arguing what's known as forum nonconvenience, that Wayne County, Michigan is not the proper court to have this case litigated in. They claim this guy needs to file a lawsuit in Slovakia. It happened over there. That's where, he lives. He's a citizen of Slovakia. That is the appropriate forum. And there's all this convoluted law about
very complicated.
Yeah, about how courts
arbitrary too.
Right. And part of the problem too is most of this law, as is a lot of law, is based upon, we live in 2024. We have Zoom. We have, means to get pieces of evidence across the country within a couple days, right?
Yeah.
And a lot of this case law talks about, well, if all the witnesses are in Slovakia, everyone's got to go to Slovakia, which was probably true 20, 30, 40 years ago, right? But now we have Zoom. We do Zoom depositions all the time. Translators, it's not an issue. And so the defendant in the case, that was their big argument. Everyone's going to have to fly to Slovakia. The evidence is in Slovakia. We got to go there. It's way too inconvenient. It's way too much of a burden.
And really what they knew was the guy was screwed in Slovakia because he had already been to like 3 Slovakian attorneys, right?
Right.
And they told him, you got to go to Detroit, Michigan, right?
I don't understand the European laws that much, but from what I could tell, there's very limited ability to recover in Slovakia for a case like this.
Yeah.
And the parent company is still in Detroit. So a court in Slovakia might even say, how are we supposed to assert jurisdiction over a company that's not even in Europe, not even in the EU?
It's really unfair because when we sued them here, the defense attorneys are saying go to Slovakia. And then I guarantee you, had he actually found an attorney in Slovakia who was able to take the case, and he tried, and then actually got into the court there, they would have said,
go to
Michigan.
Yeah.
And so it's a defense tactic. And it worked in this case, unfortunately. I think the laws need to be updated and changed on that because the judge, who was a very good judge in Wayne County, and the law was murky, and said, yeah, you got to go to Slovakia. And now this guy, the reality is he can't go to Slovakia. He's done. The case is done. He's blind for the rest of his life. We did the best that we could. And really, really worked hard for him. But he's not going to see justice for this.
No. Yeah, really unfortunate. I do think the laws probably need to be updated. Just like I said, I mean, we live in a different world now, and it's not a big thing to have witnesses in other corners of the world. Zoom is a thing.
That's right.
It's not a problem anymore.
Which has opened up, like, from a practice perspective. So, like, 10 years ago, before COVID, before Zoom, we have a case in even like the UP, for example. Like you and I had a case in the UP together. Remember against General Motors where it malfunctioned and a car malfunctioned, and you had to be it was very difficult to take cases that were in remote areas of Michigan because you'd have to go up there and you're spending so much time to go to the courthouse, to go to depositions, just driving there or flying in. Now, because of technology, it has opened up access to justice, I think, because we can take those cases a lot easier. If you have to do a deposition in Northern Michigan, you can do it from our home office in Detroit on a Zoom generally.
Exactly.
And so we're able to help people in areas where we wouldn't have been able to do that before simply because we couldn't have spent the man hours and the resources to be able to do it. So,
absolutely.
But I feel bad for that Slovakian case, but it's unfortunate. But so, look, the law is sometimes unforgiving,
Very true.
The law.
Very true.
So, all right, Tyler, it was awesome to have you on the show. Thank you so much. You did a great job. We're very proud to have you as part of the team.
Thank you, John. It's a pleasure.
Yeah. Keep up the good work. Thank you, everybody, for watching another great episode of Cases Gone Wild. And thank you to our special guest and great attorney, Tyler Joseph, for joining us today. If you or someone needs help, legal representation, whether you're hurt in Slovakia on a crazy exploding bike or somebody shoots your nuts off in Northern Michigan, please call us at Marko Law. That's www.markolaw.com. You can go to our website. You can find Cases Gone Wild on there, or give us a call, 833-MARKO-LAW. That's 833-MARKO-LAW. We'll see you in 2 weeks on another Cases Gone Wild.